Hello and welcome to today's webinar brought to you by Building Magazine in association with Fenwick Elliott. My name is Chloe McCulloch and I'm Deputy Editor at Building Magazine. This webinar is an essential construction law update. In other words, a guide to the current legal landscape, specifically what you need to know about BIM, Brexit and adjudication. Here to provide insights we have two legal experts from Fenwick Elliott, Jeremy Glover, partner, and Ed Colclough, associate. But before we get started, a quick reminder that during the webinar, you can post questions to the panel and we will try to answer as many of them as we can once they've finished their presentations. Also, you may like to know that all the presentations will be available on demand on our website, building.co.uk, from tomorrow. So let's get stuck into our topic of essential construction law with a presentation from Jeremy. Over to you.
Great. Good morning, and thank you, Chloe, and thank you, Building, for inviting Fenwick Elliott along today. For those who do not know us, Fenwick Elliott is the UK's largest construction and engineering law firm, and we work on a large range of projects both here and across the globe. Ed is from our project side, and I tend to be more involved when problems emerge. And together, we want to take a look at three key issues which are of particular relevance to our clients. Two of these, BIM and Brexit, regularly hit the construction, if not the national headlines. The third, with less fanfare, has over the past 20 years become the primary means of dispute resolution in the construction industry. And as we will see, potentially there are moves afoot which might, just might, lead to changes and maybe, who knows, extend the ambit of projects to which adjudication applies. Starting with BIM, building information modelling. Much talked about, constantly evolving, particularly as technology advances, and not something we would stress from a lawyer's point of view. We view as a problem, hurdle, or obstacle. Anything which potentially benefits the construction process is clearly a good thing. And one thing the past 12 months has told us is the importance of clarity and understanding just what you have signed up to. And that's something which applies to your contract as a whole and not just your BIM obligations. As it happens, in the summer of 2017, BIM crossed the doors of the Technology and Construction Courts for the first time. And that's why we've started with a what is BIM slide, even though I've no doubt that everyone listening has their own definition and understanding of what BIM is. Here, Mrs. Justice O'Farrell's definition of BIM is bang on point, because she refers to both the software element and the importance of efficient planning. BIM is more than information modeling. It's about management as well, as can be seen from a brief review of the case here. In fact, it's important to note that the case was about more than BIM. There was an issue with the entire CDE. And by CDE, I mean the Common Data Environment. The NBS has defined CDE as a central repository where construction project information is housed. The contents of the CDE are not limited just to the assets created in a BIM environment. It includes all the project documentation, the graphical model, and non-graphical assets. And just as an aside, if you don't know, the NBS is a fantastic resource for all matters construction, not just BIM. But here, the key to the case was about the coordinator of the CDE. The coordinator is the one who provides the codes or passwords to the platform, the one who allows access to the data and information. And here it was MacDonald who held the passwords to the CDE. And that gave MacDonald a commercial edge when a fee dispute arose. MacDonald simply denied Trant access to the servers hosting the design information. They changed the password, something that's incredibly easy to do. Trouble was that it led to delays on the project. Trant argued that without restoring access to the relevant database, the project couldn't be progressed. Trant was saying, well, we're actually going to have to start again. We don't have the information that we needed. So what was the TCC going to do? In the end, they slightly blunted the initial commercial edge that MacDonald had and actually granted Trant an injunction compelling MacDonald to make the design information available. But equally importantly, to balance things, they ordered Trant to make a payment into court of £475,000, pending a final resolution of that dispute. And why did they choose that figure? They chose that figure because Mott MacDonald had served a payment notice, an interim payment application seeking payment of that sum. No pay less or payment notice had been issued by Trant. Now, Trant had argued that there'd be little harm to Mott MacDonald providing access to the design data because it was already out there, it had already been provided. Now, this is quite an important point, I think. The decision suggests that access to the CDE cannot be revoked once the design information has moved from one party into a public folder, into the more public domain. And here, of course, it was particularly the case where Trant was prepared to pay compensation. They recognised they owed Mott MacDonald something. So why is all this important? It's all about securing access to the data. The case raises an important point about any electronic data. Who holds the key to the data? It's vitally important. That individual, that company, they're the gatekeeper of all project information that's held digitally. Should the employer own the data? Many would say, well, absolutely yes, that's what the employer pays for. But of course, that's what this case was all about. The employer hadn't paid the money. Should they, in those circumstances, should they still have access? And also, not all employers have technical capabilities to do this. But why the case is important? Because it flags up things that people need to think about when they're negotiating, when they're drafting their contract obligations. Forms of appointment, contracts, BIM protocols, whatever. They need to be reviewed to take into account the decision in Trant. Parties need to ensure that they're adequately protected and ensure that data required for the success of the project as a whole is not allowed to be used as a bargaining tool in a subsequent bi-party dispute. So the Trant case shows us that what the contract says is key. That's very important when it comes to looking at the standard forms. And as we all know, during 2016 and 2017, there have been a number of amendments to many of the standard forms. JCT, throughout 2016, issued updates and amendments to their standard forms. The design and build contract is the one we probably most associate with BIM. And just looking at some of the key things you need to think about from the JCT's point of view, they think there should be a BIM protocol. The BIM protocol is a contractual wrapper. It's one of the most important documents. It sets out in detail who is supposed to do what and when. The JCT, as far as they're concerned, the BIM protocol is a contract document. They don't specify a particular protocol. The CIC has introduced one, has a first edition. But alternatively, the JCT haven't drafted their own. And the JCT make a number of other points. When it comes to contractors' design information, contractors' design documents, there should be a specified design submission procedure. Again, that's the who does what, when. From an employer point of view, what if they are required to provide any information? Again, contractually, under the JCT contract, an employer will be in breach if they don't provide the information within the time frame set out in the BIM protocol or within the contract documentation. And contractors, think about your subcontractors. What must your subcontractors supply in order for you to comply with your obligations under the main contract? Now, the thing about these things are, I know we're talking about a BIM-enabled project, but they're the type of things that any contractor, any employer should be thinking about, regardless of whether BIM is in part of the project or not. And as you'll see, different contracts do things in different ways. On the 22nd of June this year, the NEC4 contract was released. One point to bear in mind is just because we're talking about the introduction of new contract forms, it doesn't mean, to take the example of the NEC form, that on the 23rd of June, all NEC contracts suddenly became in the NEC4 format. New contracts are there. People are encouraged to take them up. But lots of people like using what they're familiar with. You find people using contracts that date from JCT, the 1998 version, FIDIC, the 1999 version. The new contracts aren't immediately taken up. But what they do is they take note of developments. They take note of legal precedents. So with the NEC, the NEC3 had a guide how to use BIM. That's not a formal part of the NEC form of contract, possibly because the NEC recognises that people have become more sophisticated. They know and understand more about BIM. With the NEC3, they've moved from putting BIM as a Z clause to now it's a secondary option. And again, NEC, like JCT's, not so keen anymore on the CIC BIM protocol. NEC3 guide said use the CIC BIM protocol. There's no reference within NEC4 to the CIC protocol. And I think actually, in one sense, that's a little bit unfair because the premise behind the CIC protocol was to get a standard protocol document that everybody uses. And that's a good thing. If everyone's using the same type of document, the same standard document, using the same terms, there's less likely for confusion. I think the one difficulty is it's well known that the CIC is currently drafting a second edition, an update to their protocol, and we'll have to see what that looks like when that does come up. Another issue that the NEC changes brings into focus is the language used, the terms that are used. They use slightly different terms to standard. Information modeling is not something that's used elsewhere in the UK, and that might be because the NEC is looking to promote itself on a more international basis. I'm not sure, but again, terminology, it's key. Whatever contract, whatever part of the contract you're looking at, you do need to understand what the terms mean. And internationally, there's the FIDIC form of contract. Now, FIDIC's an example of a form of contract that currently doesn't mention BIM at all. There's a new edition of the Rainbow Suite coming out in December. The drafts that have been released, they show they're silent on BIM. And that's slightly surprising because FIDIC's engineers, and most of the project these engineers are working on, it's going to be BIM-enabled projects. But I think it's under review, to be fair to FIDIC. They recognise that it's something that needs to be done. And their position is likely to be that parties should include a BIM protocol and an execution plan, which is like a schedule, getting things done in the right order when things need to be. But it means that without a protocol, without specific reference to BIM, you must more than ever pay particular attention to the detail of the employer's requirements. And of course, that's something, there's a Supreme Court decision in the summer, the MTH and Eon case, where the Supreme Court looked in the detailed technical requirements to find a fitness for purpose obligation on the contractor. And sometimes you look at overarching contracts, frameworks. 2016, 2017 has been the introduction of the Framework Alliance contract. Now that's supposed to be compatible with any combination of standard form contract conditions. It's like a multi-party BIM protocol. It encourages early contractor, early employer, and early supplier involvement. This early involvement of all parties to the contract is something that is quite a key factor of making BIM work. And it's a bit of a change of approach, a bit of change in how we do things, but it's a good thing and something to be encouraged. And if you look at the words of the Framework Alliance contract, direct relationships, they're seeking to integrate the work of the team members. We're looking for mutual reliance on agreed deadlines. It's all about a change in working. It's about the more collaborative approach. I mean, there's a lot of talk about the fact that it's good and parties should be encouraged to work collaboratively. I think one of the advantages of BIM is that it actually encourages, if not forces, people to work more together and encourages a change in the way we operate. But the new contracts, 2016, 2017, they highlight a number of issues that you need to consider when you're working on a BIM-enabled project. It's like a checklist. Different contracts use different terminology. Understand what you're signing up to. Read the protocol. There are a number of different protocols around. Understand the status of the protocol. Is it a contractual document? Does it have priority over other contractual documents? Look at your deadlines. When must you provide the information? Look at the interfaces. Will your information and data talk to, be able to interlink with data from the others? Think about copyright. Think about property rights. And how can you achieve early contractor, subcontractor, manufacturer involvement? And I think the keys when you're talking about BIM, when you're looking at a BIM enabled project, you need consistency. You're looking for clarity in your contract, clarity understanding what you're trying to achieve. You're looking for collaboration. You're looking for people to work together. Um, and that's, I think, in the construction industry, and I think when it comes to BIM, that's what people are aiming for. That's what people are striving for. I think, bluntly and slightly unfortunately, it's something which is wholly lacking in the ongoing Brexit saga, and that's something that my colleague Ed is now going to talk about for you.
Thanks, Jeremy. That's right. In this next section, I'm going to have a look at Brexit and its implications from a construction perspective, something that has certainly been marked by a lack of clarity all round. So to kick off, I intend to start with a quick recap of where we are, how we've got to where we are today, setting out what exactly has happened from a Brexit point of view. Having done this, we'll have a quick look at the potential implications of Brexit from a construction law perspective, and then some wider implications upon the UK construction sector in general. Finally, to tie it all together, we'll end by looking at what, if anything, can be done to Brexit-proof our construction contracts as we brace ourselves for the future. So on this slide, I've set out a timeline of events following the referendum vote. And the key theme here really is to map out the uncertainty generated by Brexit since the referendum. Now, speaking to various representatives throughout the industry, there's definitely a reoccurring theme of frustration at the lack of clarity as to what exactly Brexit will mean for construction and the adverse effect this is having on the sector, noting that we've been an industry that traditionally has relied on market confidence to thrive. And as you can see, this uncertainty goes back well over 17 months to the UK's narrow decision to leave the EU by a slim majority. And if you remember, the general consensus of the time from the polls was the UK construction sector itself tended to favour a Remain vote. However, following Mr Cameron's immediate resignation and an action-packed Conservative leadership race, Theresa May became PM-elect in July 2016. Now, notwithstanding a challenge to the legal process, which ended up in the Supreme Court, on the 29th of March 2017, the UK formally triggered Article 50, signalling its intention to withdraw from the EU and becoming the first member state ever to do so. I think that really shows just what uncharted territory we are currently in today. Having done this, we see a Brexit-induced snap general election held in June this year, no doubt with the intention to bolster the UK's bargaining position at the Brexit negotiation table. However, in a general election that wrong-footed the pollsters almost as much as the Brexit vote itself, we get a hung parliament with no political party given a clear mandate to govern and no clear message on a hard, soft, or somewhere in between form of Brexit. With a weaker negotiation position, in September this year we see Mrs May deliver a slightly more conciliatory speech in Florence, asking all EU member states to agree to an additional 2-year transition period, postponing a full Brexit until 2021 and only adding to this timeline of uncertainty. And just this month we see further developments, with the government under mounting pressure to release its secret Brexit studies on the impact of Brexit on construction, together with the first ever interest rate rise in over a decade. Now, amidst all this uncertainty, I've set out quite an interesting quote here at the bottom from the EU's Brexit guidance note, which states, "Nothing is agreed until everything is agreed in terms of a Brexit deal." I find this quite interesting because it really shows that any hope for a quick answer as to what Brexit will mean is not on the immediate horizon, and this uncertainty is only really set to continue. So looking at the implications on UK law, there's actually been no real immediate changes. We've seen the European Union Withdrawal Bill, formerly called the Great Repeal Bill, and we know that shall repeal eventually the European Communities Act and shall end the jurisdiction of the European Court of Justice. However, if you look at the white paper, it appears EU legislation will simply be cut and pasted into domestic law to avoid a black hole in our statute books. Parliament shall then amend and repeal and improve the laws as necessary, adopting a cherry-picking like approach, going for the most important first. A task that has quite rightly been described as potentially one of the largest legislative projects ever to be undertaken. Now, to put this into context, we see there's likely to be over 1,000 odd statutory instruments implemented over the coming years, all addressing Brexit-related changes. So, looking at this next slide on the implications on the black letter of construction law. So that's your textbook construction law in terms of legal analysis, drafting and interpretation of disputes that Jeremy and myself will be doing on a day-to-day basis. And arguably, very little changes on this front. If you think about it, some of the biggest influences on construction law come from the likes of the Construction Act, imposing a statutory payment regime, together with the rights of adjudication and suspension for non-payment, and also the likes of your Supply of Goods and Services Act, which put forward concepts of reasonable skill and care and fitness for purpose, which we've all become so familiar with. These are both very much domestically led statutes which remain unaffected by Brexit. Similar principles also apply to UCTA in terms of exclusion clauses and when they bite. So looking at the health and safety side of things, the Health and Safety at Work Act and the Corporate Manslaughter Act are again both UK driven as part of the UK's drive to become the global leaders in health and safety legislation. Now, these laws have resulted in the UK getting one of the lowest rates of fatal injury in construction across the EU, and we expect business to remain as usual on this front, with the legislation unaffected. To coin a phrase, if it ain't broke, don't fix it, and I think that is going to be the attitude of the government on such issues. The recent CDM 2015 update, which introduced the role of principal designer sitting alongside the principal contractor, was derived from an EU directive. However, there's a good argument that it's already become so rooted in the industry that any wholesale changes are unlikely. Now on to the penultimate point here. A common criticism of EU law has always been the perception of an unnecessary complex procurement process and all of its associated red tape. While Brexit does appear to offer us the opportunity to streamline the existing EU requirements with a more simplified and flexible approach, I would suggest that rewriting the procurement rules is not going to be high up on the government's agenda, particularly given the mammoth task they've already got in front of them. Again, we expect business as usual on procurement for now. And at the bottom, let's not forget the common law, that wealth of case law that has been so shaped by construction cases over the years. This shall all remain in place together with the doctrines of equity. Therefore, the likes of your prevention principle, Water Lily, Blythe and Blythe, Roxley Forsyth, all of those famous construction cases that we see argued so often through the courts and in adjudication, they're not going anywhere. Now, although construction law might not change itself drastically, Brexit will no doubt impact on the contractual negotiations of contracting parties and their appetite for risk. I've got here the CIPS, that's the Chartered Institute for Procurement and Supplies, PMI, Purchasing Managers Index for Construction, sometimes seen to show the health of the sector at any given time. Now, although this chart has a few blips, the growth in the construction sector to date has largely been carried by the house building market, which has offset lower volumes of civil engineering and commercial activity. But the key concern really is going to be that worm dips with business confidence over the next 12 months at its lowest since December 2012, mainly due to worries about the UK's economic prospects and a lack of new projects in the pipeline, all no doubt Brexit related. So to flip things over a bit now and have a look at Brexit's impact on the construction industry, there's definitely an element of crystal ball gazing here and speculation as to what could happen next. And in these next few slides, I've set out a number of areas that keep cropping up as key concerns. Now, first and foremost is labour supply. The free movement of labour has been a major asset to the success of the UK construction industry to date. And in fact, there's a good argument that EU labour has managed to paper over the cracks of a sustained lack in skilled UK labour, an ageing workforce, and a failure to invest in training and development to encourage the best homegrown talent into construction. This is perhaps one of the biggest Brexit obstacles Brexit creates for us in the industry. With close to 200,000 EU workers currently working in the UK construction sector, we're currently benefiting from an EU workforce large enough to deliver 16 Crossrail projects. And a lack of an adequate workforce has already been identified by RICS as the primary risk to a £500 billion pipeline of projects, with the potential to scupper any hopes we've got of the UK building its way out of trouble from where we are at the moment. Secondly, currency fluctuations are another issue that keep cropping up. In an unpredictable and turbulent market, we have seen a fall in the value of the pound. And although this has boosted the FTSE 100 and 250 on a temporary basis, it certainly impacts on the profitability of imports in construction and creates cost uncertainty in the market. Linked to this is the cost of goods and materials as another key issue that crops up. Following the pound's fall, one of the strongest pressures on the industry has been the rising prices of imported goods and materials. With 64% of the construction goods and materials used in the UK being imported from the EU, any cost increase or loss of tariff-free access under the single market will no doubtably dent the profitability of projects and until adequate trade agreements are negotiated and put into place. In contrast, 63% of construction materials are exported from the UK to the EU, and these have the potential to be exposed to heavy duties. Comfort certainly needs to be provided in relation to the accessibility and affordability of construction materials in a post-Brexit UK, and this is a substantial pricing risk that investors, employers and contractors will all look to avoid. Funding of projects is another real concern. I mean, the UK has been one of the biggest net beneficiaries of EU funding, with the likes of HS2 and Crossrail good examples of EU funding coming into the UK. We know nothing happens in construction until the financial taps are turned on, and without access to the big European funds with billions to invest, the UK will have to look to capitalise from alternative investment forums. Another point to watch out for is that in a cautious market, there's often a tightening of lending criteria, making it more difficult to secure finance for new projects, often resulting in onerous contracting terms as the funders look to hedge their risk and the market exposure. So I guess in summary, all of these Brexit-related factors create a perfect storm of uncertainty, leading to a lack of market confidence and the risk of projects becoming delayed and even being shelved. From the contractors and developers I've spoken to, there's definitely a general feeling that it's already taking longer to get projects off the ground now than it was at the beginning of the year. What is clear is that the UK construction must maintain itself as a sound investment going forward. And I think a real frustration here has been a perceived lack of vision from the government in terms of what it expects the post-Brexit construction industry to look like and what are its key objectives for construction in the ongoing Brexit negotiations. I know there's a school of thought, and I think I've seen some building subscribe to it in their articles, that it's now for the construction industry to take its own initiative and make its own voice heard in terms of exactly what it expects from the government from this process. So moving on to Brexit proofing your contracts. Joey mentioned earlier the recent updates in construction and engineering contracts, and interestingly, neither the JCT, NEC 4 or FIDIC second editions expressly reference Brexit. On this, the general legal view out there is that unless a contract expressly addresses Brexit-related risks, the law will not come to a party's rescue through force majeure provisions or frustration arguments in order to get a party out of a bad contractual bargain or a contract it no longer likes the look of. I've seen a few Brexit clauses creeping across my desk in recent months, and a lot of them are quite clumsily drafted, but it's actually quite difficult to get right. But the key issues that they're typically looking to address are 1, changes in law, and 2, exposures to fluctuations in materials, taxes, import duties, and the likes of the supply of labour. Now, allocation of such risks is not a completely new thing to construction contracts. However, the real difficulty here is no doubt going to be interpreting these risks, managing these risks, and pricing against them, which has traditionally been left to the contractors to do as a risk dumping exercise. And it'll be interesting to see what scope contractors have to keep on taking such risks in an uncertain market. A key concept in all of this is, of course, what is reasonably foreseeable, and that's often the litmus test in a lot of these clauses. I'd add to this, that's something that so many so-called experts have been unable to answer themselves over recent months. So most likely it's going to be a ground for disputes in the near future. So some final considerations here on Brexit proofing your contract. From my observations, employers tend to have a crafty habit of negotiating themselves termination at will provisions, meaning they pretty much have an automatic get out of jail card if the contract turns bad for them. I imagine many contractors will be looking to obtain reciprocal rights if they can, particularly in long-term contracts, to mitigate against some of these risks. Also, in a culture where risk dumping and fixed price lump sum contracts have become expected, it'll be interesting to see if parties are forced to adopt a slightly more collaborative approach to contracting, maybe utilising the likes of BIM, as Jeremy mentioned at the beginning, as a tool to negotiate ourselves through these next few years. A lot of this will no doubt, however, depend upon the nature of the projects, with the big EPC projects, often with ongoing O&M obligations bolted onto the back of them, more exposed to the market over a longer duration of time. And finally, from the Brexit clauses I've seen, and given the uncertainty that they're seeking to address and their often vague nature, you can't help but wonder if they're going to become a fertile ground for disputes in the coming years, maybe like the JCT fluctuation provisions came in the 1980s. Remembering that parties have a right to adjudicate at any time under a construction contract, Brexit or no Brexit, this brings us neatly on to our next topic, the adjudication update.
That's great. Thank you very much, Ed. By way of a beginning, I thought it appropriate to pause for a moment to reflect on the sad death of Sir Michael Latham, which was announced yesterday. His 1994 review, Constructing the Team, laid down some significant foundations for construction adjudication. I think one of the aims, Michael had identified one of his aims as helping clients to obtain the high quality projects to which they aspire. He said that that required better performance, but with fairness to all involved. Above all, he said it needed teamwork. He said that in terms of management jargon, that was seeking win-win solutions. But I remember that he preferred what he termed to be the immortal words of the dodo in Alice's Adventures in Wonderland, that everybody has won and all must have prizes. The prize he saw was enhanced performance in a healthier atmosphere and a brighter image and better rewards for the construction industry. And whilst we may not be there yet, Sir Michael also advocated a cheaper and quicker way of resolving construction disputes backed up by legislation. That was adjudication, which has now been around for almost 20 years, and the dispute resolution landscape for construction has undoubtedly changed. And there continue to be a steady stream of cases coming before the courts, most of which, it should be stressed, are enforced. And no one should be in any doubt about that. If a party is looking to resist an adjudicator's decision, I would always tell a client that they're 1-0 down before even looking at any papers. And today we want to look briefly at payment notices, oral contracts, and costs. Taking payment notices first, in short, a contractor has a right to interim payments, and where an employer has not issued a valid payment or pay less notice, that contractor can enforce the payment of the interim payment application by way of an adjudicator's decision. And that's led to what have become known as smash and grab adjudications. And during 2017, the courts have made 2 or 3 key points in relation to these. The first may not sound so surprising, but it is that a contractor is entitled to bring these cases, bring these adjudications. But that entitlement comes with a significant but. If a contractor wishes to have the benefit of these provisions, it's got to act in a fair, open, transparent way. It can't try and sneak or hide an interim payment application disguised as something else and then expect an adjudicator or the courts to enforce that if the employer fails to provide a valid payment notice. And that's why this year the courts referred to there being a high threshold to be met by any contractor who seeks to take advantage of the legislation. If you put forward an interim payment application, it's got to look like an interim payment application. If it doesn't, you may well lose the benefits of the adjudication legislation. And when it comes to payless notices, the courts take a slightly different approach, it seems. They'll look at things in a broad way. They'll look at the overall position to determine whether or not a payless notice has been given. In the Surrey and Sussex case, the court had to consider whether an email attaching the final certificate could be considered to be a valid payless notice. Now, if you looked at all the documents attached to the email, it set out in quite detail the valuation of Logan's work. There was a breakdown. And so that was going to be the only sum to which Logan was entitled, whether by way of a final account or an interim payment. So taking things on a broad level, one purpose of the email and all its attachments was that it was responsive to an interim payment notice. Looking at it another way, the documents provided what's known as an adequate agenda for an adjudication about the true value of Logan's works. There was a brief, detailed breakdown of the trust's position. There was nothing more that Logan needed to know. And so here, the court saw no difficulty with the notion of what had happened. They'd served a contingent pay less notice. It was an either or. The contract administrator was simply saying that if he was wrong about the invalidity of the interim payment notice, which was his primary point, then all his information about the final certificate reflected everything he wanted to say in response to that. And the court said that was absolutely fine. The key there is there was nothing more that Logan needed to know. Because whilst the courts might take a broad approach, they don't lean over backwards to help the employer. This case here, Muir Construction and Capital Residential, it's from the last 2 or 3 weeks. It's a Scottish case. And the key here was the detail of the figures. The employer had just said pretty much zero. They hadn't really provided any breakdown or explanation. They'd simply said, well, you know I've got all these claims. You know there's all these problems with the project. The extent of those problems is such that I'm clearly going to be entitled to more than the sum of your interim payment notice. Hence, you get zero. But remember what the courts had said in Logan. They talked about setting an agenda for the adjudicator. Here, there was nothing that could provide an agenda. The judge said there was no calculations put forward. There was no specification to allow the reasonable recipient to make any sense of the figures. It was just a simply broad, well, you're not entitled to anything. And that wasn't good enough. The courts went back to the wording of the legislation. A pay less notice needs to set out the grounds for withholding and the sum applied to each of those grounds. They've got to set out what I've said before, is this agenda for hearing. So these decisions are quite important because they talk about clarity, they talk about transparency. The court acknowledges that smash and grab adjudications are perfectly fine. That's what the legislation provides for. But they've got to be done in a clear, open, transparent way. I think that might be one of the issues, one of the problems that the courts have with oral contracts. The 2011 amendments to the Housing Grants Act extended the adjudication provisions to include oral contracts. But of course, the difficulty there is, first of all, you have to decide what the terms of the oral contract are. And earlier this year, Mr. Justice Coulson, who of course has just been elevated to the Court of Appeal, had a case where there was an oral contract. And his problem with it was the adjudicator had to decide the meaning of the terms of the oral contract. And then on enforcement, the court had to determine the meaning of the oral contract. And they couldn't do it on a summary process. There had to be a hearing where people gave evidence as to who said what. So instead of having Sir Michael Latham's quick, cheap dispute resolution, they had a process which lasted some 16 months and incurred considerable costs. And that actually led the judge to say, and it's quite strong words for a judge, to say that Section 107, which was the provision that said adjudication would only apply to contracts in writing, was in his view unthinkingly repealed. As he's clear, he says it led to the opposite of the quick, cheap dispute resolution service that adjudication legislation was intended to provide. He's not saying that adjudicators can't make a decision about the oral contract. He's saying it makes the process uncertain. If a process is uncertain, it becomes more expensive. And another issue that's arisen out of the 2011 amendments to the Construction Act, as well as the late payment of commercial debts legislation, is the question of whether or not a party is entitled to recover its costs of an adjudication? I think it's fairly clear that, in my mind, that this question was answered during 2017. But looking back, to many people, they'd say, well, maybe you can recover your costs. And in doing this, they looked at the case of Lulu and Mullally. Now here, in this adjudication, Lulu included a claim for debt recovery costs. Under the Late Payment of Commercial Debts Act, a successful party, they can recover their debt recovery costs. And a lot of people have said, well, adjudication, quite often I'm looking to recover a debt. Therefore, under that legislation, I'm entitled to my costs. And here, the adjudicator agreed with Lulu. Now, Mullally said, well, that's not right. They said that the adjudicator didn't have jurisdiction to make that decision. Now, the important thing to remember here, and this is one of the reasons why courts tend to enforce adjudicators' decisions, is that they look to see if the adjudicator had jurisdiction to make the decision. And they don't look to see whether the adjudicator got the answer right or wrong. They simply look to see if he answered the right question, if he answered the question that was put to him. Here, the court acknowledged that one of the questions, or part of the overall question that had been put to the adjudicator, was the question of costs. So in enforcing the decision, he wasn't saying, yes, I agree that adjudication costs can be recovered. He was saying, yes, in this instance, the adjudicator had jurisdiction to make the decision. He did. And I think there have been a couple of cases which suggest that the courts are actually thinking in the opposite way and would answer the question, can a successful party recover the costs of an adjudication, with no. Mr. Justice Coulson last year noted in a case involving the costs of a legal proceedings, the costs of after Part 36 offers were made, he said, in an ordinary case, a party seeking to recover a sum awarded by an adjudicator is not entitled to and cannot seek the legal costs it incurred in the adjudication itself. And to me, if a party can't recover from the courts the legal costs incurred during the adjudicator process, I don't see why they should be entitled to recover those costs from the adjudicator, him or herself. And I think further support was for this position. We found that in the summer, Mrs. Justice O'Farrell, case of EnviroFlow and Redhill, and she set out the two opposing, if you like, contractual or legislative. She set out the two opposing statute positions. Late Payment Act implies a term into the contract that a successful party is entitled to its reasonable costs of recovering a debt. Construction Act says that the costs of an adjudication can only be awarded where such a provision has been made in writing. In the EnviroFlow case, it was an oral contract. Therefore, no argument could be made that the cost of the adjudication or provisions as about the costs had been set out in writing at all. In that instance, the Construction Act clearly trumped the provisions of the Late Payment Act. And to me, that's pretty conclusive, because you either have something in writing in your contract which deals with the costs of adjudication, or you don't. And if you don't, you can't award the costs. And so in my mind, following EnviroFlow and WS Futures, adjudicators should not be awarding costs under the Late Payment Act. I accept that there's still a risk if adjudicators do award costs following the Lulu decision. It's quite possible that decision would be enforced, of course, unless you have an oral contract. And very briefly, talking about costs, what about the costs of adjudicators? If the adjudicator says you have to pay their costs, do you have to? In short, the answer is yes. And this case, again, from this year, sets out how the court would approach looking at the reasonableness of the adjudicator's costs. Now here, there was a claim in the value of some £600,000. The adjudicator was operating between the 19th of January and the 16th of March. So it's about 2 months. So it's twice as long as your normal average adjudication. But he incurred fees of just over £30,000. And these were challenged by the paying party. So the court looked at the reasonableness of the costs. And he said, and the judge said, well, you adopt a robust approach, and you have to take into consideration the circumstances under which the adjudicator is operating. He's working at speed, he's working under pressure, he's going to be challenged throughout the whole process by both parties wanting to throw information at him or her. And quite often the adjudication, it happens all the time. Almost every day you sometimes see correspondence, emails from one of the parties. And what the court does is they take a general overall approach. They're taking this broad brush approach. They're not going to go into fine detail to consider whether or not the fees are reasonable. They're going to look at the thing in the round. And here, the judge looked at the detail and complexity of the issue, and he thought that the fees were reasonable. So in challenging the £30,000 fees, the paying party then had to pay the adjudicator an extra £3,000 in respect of fees that he himself had incurred in defending the claim. And then there were the legal costs on top, both of the adjudicator and the paying party. And I think the courts are very unlikely to be persuaded by technical arguments to say you don't have to pay an adjudicator's costs, and it'd be very hard to knock down an adjudicator's fee bill on the basis that it's unreasonable. But all this goes to the costs of adjudication. And we want to finish by just highlighting briefly the fact that the government has just introduced consultations on both the Construction Act and retentions. These were launched by the Business Department on the 24th of October, and replies are due to be submitted by the 19th of January. You can see that the focus of the consultation is on increasing transparency in the exchange of information relating to payments. And I think that can be seen by the 3 judgments and the 3 court cases that we highlighted earlier. That's something that the courts are very, very alive to. Encouraging the use of adjudication. If adjudication is quick, cheap, and you know that it will be enforced, then that's a good thing. And that's the 3 basic principles that Sir Michael Latham was talking about. The third point is it's strengthening the right to suspend performance. We haven't talked about suspension. It doesn't seem to happen very much, probably because it's quite a serious thing. So it'll be interesting to see what does happen. Personally, I think it would be good if a formal stop was put, just for the avoidance of doubt, on the costs argument. And maybe now is the time to extend adjudication to all parts of the construction industry. But it's also important, just to finish, that the government's looking at retentions. And we've put on the final slide there links to the government consultations. And on the retention one, there's some research that's been carried out by Pye and Tate. And in some senses, the research is not so surprising, although it's slightly disappointing that these are the conclusions. And they are that retention monies are being lost to contractor insolvency. Some contractors, surprisingly, are making payment of retentions conditional, even though pay when paid provisions are banned by the Construction Act. And then they look at the unjustified late and non-payment of retentions. It remains a significant issue for contractors, and probably more importantly, subcontractors. And one of the stated aims of the retentions consultation is to investigate alternatives to the retention mechanism. And this is why they're talking about a retention deposit scheme or a trust account, a proposal that retention monies are held in trust in a separate ring-fenced account. The idea being that that eliminates the risk of delayed or non-payment for the subcontractor and still provides the contractor or employer surety against defects. And I think we'd just end by saying, have a look at the consultation. And if there are questions that you want to answer, things that you want to get across, what's right or wrong with adjudication and retentions, it's important that you, your company, your trade association, your professional body you're part of actually respond. I mean, it's like voting in Strictly or the X Factor. If you don't vote, your favourite gets voted out. If you don't reply, you can't complain when nothing's actually done about these things. But we'll see. I mean, government changes take time, and as Ed has said, maybe at the moment the government has slightly bigger priorities, but replying to the consultation is important because it's likely that changes will filter through eventually. But that was all we had to say, and hopefully we've left a little bit of
Great.
time
Well,
for
thank
some
you very
questions.
much, Jeremy and Ed. I think that was really, really informative and really good to end on that consultation note and useful information for listeners there if they want to feed into that consultation. I actually had a quick question just on, when you were mentioning those deposit schemes and trust accounts, would those work along the same lines as I know people like Rudy Klein have been talking for a very long time about project bank accounts? Is that similar?
I mean, I think it's all part. It's not actually this wouldn't be quite the same as the sort of formal project bank account, but it's all part of the same process and the same idea. Um, so yes, I mean it would be one of the things that Rudy Klein has been talking about. I mean, to be fair to him, he's been talking about these things for many years. And I mean, it must be quite good news for him to actually see that perhaps finally some big, these things are going to be
Yeah, so that seems to be
actually
gaining
addressed.
traction. Well, that's interesting news. And so I think just over to some of the questions from readers. I think one of them was about the CIC protocol. I was just going to quickly just chip in before I go to the listener's question, but you mentioned that it's due to be updated. Is there any idea of the time frame on that, or is it's just being worked on at the moment? Yeah.
It's not something I know. I mean, I understand that it's being worked
Yeah.
on and being worked on very
Okay,
hard
so
by
I
sort of
think the
various people.
question really was about it was about whether these protocols just get amended anyway by the various parties. So let me just go back to the wording of the exact question, but we'll just I think it was along those lines of yeah, in my experience, most clients edit the CIC protocol to remove the reasonableness. Does that come across as true to you?
I mean, people can't help themselves but amend contracts. I mean, it's one of the bugbears generally. I mean, it's not just protocol; it's the standard forms. Um, yes, people do amend these things. Um, I think at the end of the day, it's usually better to sign up to something because you've got the certainty of knowing what has been agreed. Um, and yes, I can understand why people are sometimes saying, yeah, well, clients edit the CIC protocol to remove the reasonableness. I mean, that's the commercial advantage that employers and clients have. Um, the quid pro quo is that the employer and the client needs the design and build contract. The employer needs the design information. So there is some flexibility there. Um, the unhelpful answer is yes, I
Okay,
agree.
fair enough. There's a slightly more detailed question again on BIM, but specifically NEC4, and it's asking about your views on the potential gap in liability as the client is only responsible for the model in so far as no defects in the project information. Um, so I'm just it's quite a lengthy question to go through exactly, but it's like what happens if the model has a defect arising from the project information, but due to a non-negligent error by the contractor? Is that, I mean, is that possibly a bit too detailed to answer here? But are we getting at something about liability in NEC4 and
I mean, my short answer is that I agree with the question, and there is a potential gap there in the liability. As you say, unfortunately, it's also kind of thing that's actually there is
yeah.
the longer answer would take us
Yeah,
beyond
yeah, no,
our
no, that's
hour,
fine. I
unfortunately.
think we've also had question about lean construction, um, and I don't. That's slightly so. Lean construction is growing in application in the UK as a collaborative process. Why is it not being referenced in standard forms? Is that something that you've had many people ask about?
It's not something that we've had crop up ourselves, um, but as a collaborative process and a collaborative principle, it's not surprising that that's the type of thing which is beginning to crop up more because we are seeing a general change in trend, a change in attitude, and an understanding there's got to be a change in the way people work, and that's using collaborative forms of working. The difficulty is actually how you put on paper how parties should collaborate, because then you're forcing them to do something which is actually the opposite of collaboration.
Yeah.
In the
Okay.
first place.
There was one other question that takes us back to Brexit, but basically the question was, should people be amending their forms of contract to take into account Brexit? So, you gave us a really nice overview, and you said that you are, Ed, you are beginning to see some clauses come through, but they're not particularly well drafted. So, what would your advice be, that to steer clear of it, or if you are going to introduce those clauses, be very careful about the drafting?
Well, I think there's not going to be a one size fits all. It's got to be tailored to the particular project, what the risks are, what your particular risks are on the project. It's certainly something that people should be thinking about at this stage for sure. And I think that's probably why the standard forms haven't come up with an answer, because it's really got to be given a bit of thought as to what are the risks you want to mitigate, and actually sitting down with the counterparty you're going to be contracting with and thinking about how a sensible
Yeah, so
resolution
I
is going
think
to be
it's kind
reached.
of, people are wanting a kind of a quick fix and just get the lawyers in, but actually it's about thinking about your business really carefully and think, yeah,
Absolutely, yeah. It's as much led by the commercial guys, the guys on the ground as well, feeding into the legal drafting in terms of what risks need to be
yeah,
covered up and
okay,
what the
that's really
exposures are.
helpful. So moving on more now to adjudication. So this is a question from David, and can you issue a pay less notice without first issuing a payment notice on an interim application? Does that make sense?
It makes sense, and the question is a fair question, and it's a fair question rising out of, one reason that people think that you should be amending this payment legislation is because it's unnecessarily complex. My practical answer would be, if you haven't issued the first one, you should try very hard to make sure you do issue the second one. So you should be, if you haven't issued the payment notice, look to get the pay less notice in first, because then that gives you something
Okay,
you can
all
argue
right.
about.
I think we'll just end on one final question, which is probably a bit mean, actually. I think it's someone's asked. I've heard many and read many definitions of BIM, but I'd love to hear your definition. Is that really mean? I think that is. I think it's, we had the legal definition at the start of the presentation, didn't we?
Yeah, I think I've already given away what my definition of BIM would be, and it's actually BIM with a double M, so it's a bit of a cop out, but it's building information modeling and management. As I said, it's a two-stage process. It's not just about the software; it's about how you manage
That's
the
great. I think
process
that
as
gets
well.
us out of that horrible question. But no, thank you very much, everyone, for your questions. So just, I think that's actually probably all we've got time for today. So many thanks to Germany and Ed for their presentations. Thanks also to Fenwick Elliott for supporting this webinar. And finally, another reminder to listeners that you can access the presentations via our on-demand service at building.co.uk from tomorrow. So we have a 24-hour gap, and then you will get it tomorrow. So please do look back at our website. Thanks again for listening, and goodbye.